mentioning.
Serial number 23. Custody matter, the appellant is acquitted from by this whatever authority on the basis of only fine has been imposed upon, but he could not deposit the fine amount within this collected time, and therefore he has been arrested.
Naturally,
so
he will be arrested.
My lord, the only period for surrender.
You went to the Supreme Court, or you did not?
Only for the modification of the period.
Did you go to the Supreme Court, or
no,
you did not?
Only I will.
Fine has been deposited?
I am ready to deposit the fine.
Ready me? Okay.
Period extended over then.
You come at 3 o'clock. 3 बजे.
मेरी क्लास serial number 21 मैंने from the list मैंने कल ही हमने इसमें
No adjournment on mentioning. I don't
वकालतनामा
agree.
मुझे फाइल किया दे सके इसमें.
Can you understand Hindi, English, Urdu? What language do you understand? If you whatever you want to say, let the case be called out. We will hear you.
For final disposal, item 1, the rupees 5107 of 2017.
List of dates and synopsis were given, and on the last working Friday, the matter was heard also by the government.
That's right.
The issue is that basically, I'm just narrating the
What is
facts.
upper second class? And from
higher second class.
From where do you get that?
That is there in the university statutes.
That it will be more than 52.5%.
Yes.
Where is that?
Higher second class is.
Kindly show it to me.
52.5 right now. Because
That is the crux of
that
the
is the crux. Because,
Where is that?
Just
And
let me find out.
when was it declared to be so?
It is. We have made a statement with regard.
Statement will not do, Mr. Banerjee. I want to know it from the statute, some provision, some circular.
And just whatever is there on the record from there on, I will just show. Because I cannot dispute that high second class is more than 52.5%. That is settled position. I cannot dispute.
I don't know. You see, whatever you say cannot become a settled position unless there is a judicial pronouncement or there is a statute. Your statement will not become a settled position, right?
With regard to that date, that was
52.5%, because higher second class is a very vague statement. I just want to know from where do you get 52.5%? Is there any university UGC regulation, or there is any university circular, or there is any statute to that effect? From where do you, because the advertisements also does not contain 52.5%.
It only says high second class.
So that will clinch the issue, na? From where do you get 52.5%?
And that is one issue which is important. And other thing is that this higher second class, this has come from the year 2/1/1977.
Your appointment was initially made
And
against
leave vacancy.
leave vacancy.
Leave vacancy.
So therefore, you cannot have any claim on that.
But the records which is maintained by the university is the principal employer, and that mentions everywhere. My date of initial appointment was 2/1/77. That is when I gave joining in pursuance of that leave vacancy. Since there is no break, initially that was against a leave vacancy by the governing body. Subsequently,
So that was also against an advertisement.
no, that was not against it. Subsequently, an advertisement was made, and there is.
And thereafter, you participated in the
Yes,
regular
the selection
appointment.
process, and in that selection process, the university representatives, experts were also there.
That's
They were
right.
also-
So that is a subsequent appointment.
Uh,
Totally delinked from your leave vacancy appointment.
Since I am submitting that, since there is no break, and since in their record they have mentioned
How
as
can you
to-
submit that?
No,
There is
they-
this fresh selection process.
fresh selection, but they have all along mentioned it as 2/1/7.
We
Even
will not.
without going.
They
to
have
the-
raised an issue in the written submissions also, that it is to be decided as to whether your appointment will be considered prior to 1977 or post 1977.
Now, if they are raising something in their written submission which is there not on record, which they are not disputing otherwise, either in the impugned order.
Are you disputing that you were appointed against leave vacancy and
No,
subsequently?
I am not on that. I am even not on that.
They are on that. Therefore, you need to answer.
Because they cannot plead something or state something in written submission which is not there in the impugned order or in their counter statement.
Please don't be so technical about it, right?
Because
So you have to establish your case,
Yes.
right? So you establish your
I'm
case.
just narrating the factual details. I'm just narrating the facts.
I have seen your facts.
So now there are certain important things. His appointment was made in pursuance of a selection which was done by a selection committee. University experts were also there, and then thereafter he joined, and he joined against a sanctioned post. The post was sanctioned by the university. He joined.
When did you join against the sanction post?
He joined against.
And
the
from
sanction-
where do you get this?
1/9/1978.
This is post advertisement, not against leave vacancy.
No, it is post advertisement.
No, so you forget about that. You just your initial appointment against leave vacancy is dated.
That is dated 22/12/1976 is the appointment letter.
Just a moment. 22/12/1976. Leave vacancy for a limited period.
Yes,
How much?
that mentions. I'm just reading the language. It doesn't mention. With reference to your application dated 7/12/76 for the post of lecturer in English at this college and the subsequent interview held on 21/12/76, I am directed to inform that you have been appointed to the aforesaid post on purely temporary basis. On purely temporary basis in the leave vacancy of Sri Janardhan Prasad, lecturer in English. No period is mentioned. You will be paid a consolidated salary of Rs 400 per month from date of joining. Please note that you have to join positively on 2nd January 1976.
Where is this letter?
This is page 126 of the memo.
Page
Page
126.
126.
Okay, this is the amended writ petition.
Yes, amended.
Okay.
I'm referring from the amended.
All right. Then what happened?
And thereafter he gave his joining on 2/1/1977.
2/1/77 joined.
That joining report is page
Yeah.
126.
You said that this particular joining was against vacant sanction post. Is that correct? How your appointment or your engagement against leave vacancy can be said to be your engagement against a vacant sanction post?
That will be apparent from another document.
Not the document. Admittedly, you were for leave vacancy, isn't it? How your appointment against leave vacancy can be said to be against vacant sanctioned post? A pure question I am putting to you. How do you say?
Now sanction post, there was a post sanction.
Person was already working on the sanction
So
post.
therefore I sanction.
How do you say vacant sanction post?
It was a leave vacancy. I am not saying vacant, but it was a sanction post.
That's right. But it was just a leave vacancy and it was occupied by a person.
Yes. But the subsequent appointment,
Date of advertisement?
the date of advertisement is 29/7/1978
29/7/1978 advertisement.
in Searchlight newspaper.
That's right.
Ah.
There is no allegation that it was not advertised.
Yes.
Right. Done. Then
Then
he participated.
He participated. He appeared before panel of experts of University Service Commission.
Your percentage is 46%.
Yes, 46%.
The advertisement says higher second class.
Higher second.
Okay. Advertisement is not mentioning about any percentage.
No, it mentions high second class. Higher second class.
Then when were you appointed?
Thereafter, 29/8/1978.
29/8/78 appointed.
That is Annexure 3 at page 120.
You say that your appointment was under the statute of 1977. Where is that statute?
That statutes. 77 statute is not on record.
Please don't tell me this. I can't decide cases.
Because
like this.
77 statutes we only referred for the reason that these 77 statutes still then it was not prescribed that high second class
We
degree.
do not know what is your appointment is under 1977 statute.
Even without going into those issue of high second class, I am proceeding on the other events.
So you want to give up this plea? I will record it right away.
I'm not giving it up. I have.
So therefore, you complete your first point. Don't jump from one point to another, right? Your appointment is under 1977 statute, which is not on record and it is not even with you.
It is with me.
Okay,
It
show
is
it to
with-
us. 77 statute.
Yes.
Let's have a look at that. ये देखिए कौन सा किताब है इनका?
This will be in the university manual. I will just refer to the relevant.
Where is that?
I will just.
What is the date of this statute?
There is an amendment in that 1980 statute.
You were appointed as lecturer.
Lecturer.
Lecturer in English.
English. Page 140 of this, if I am having the same book,
114.
114, part 2 of this manual.
This is revised statute.
Revised statutes.
I'm talking about 1977 statute.
1977 statutes, the cutoff date is there. The cutoff date is there, that statute is specifically.
Please take down. Counsel for the parties are present. Counsel for the petitioner is not able to answer the query of this court. Admittedly, he was appointed under the statute of 1977, but he is not ready with the statute, which in the opinion of this court is required to be seen. Post on next Friday. He undertakes to give advance copy of the statute of 1977, much prior to the next date of hearing. You also find out, yes, madam, excuse me, the counsel for the respondent is also directed to apprise this court as to how 52.5% is considered to be higher second class, right? Any circular or statute pursuant thereto be produced before this court. Next.
Item 2, WPS 6207 of 2017.
Let us see the report of the Sexual Harassment Committee.
Yes. What is the convenience volume which we have given?
Lie jara dejiye. Respondent is there. Where is the report in this volume?
We also want to see the
Report of the Sexual Harassment.
department inquiry proceeding is 61.
I want to see the report because everything is based on that report.
Cash report is not, so
page 31.
31.
Page 31.
That's Is there any finding of false
Yes,
complaint?
yes. Kindly come to page 42.
42.
Conclusion. This is the basis for initiation of the proceeding against me.
Yes.
Page 43.
Not substantiated, I think it's not the same as false.
But what they say in 4.2 is the committee deliberated and reached to the conclusion that the allegations of Professor Vijay Mishra against Professor Vera are incorrect. Based on the findings of the proceedings and evidence received, the committee finds Professor Vera not guilty of the alleged sexual harassment against by Professor Mishra. The committee has reached to this conclusion after giving enough and uniform opportunity and time to all parties, especially to the complaint referred to proceedings, for her to substantiate the allegation and produce any evidence whatsoever. Professor Mishra preferred to file her complaint in the police station. The matter was highlighted by media, which has caused a substantial damage to the institute's image, thereby creating an adverse impact on a wide range of stakeholders associated with the institute. The committee feels that Professor Mishra could have explored internal grievance redressal process that any member of the IIM fraternities privilege. At this point, it has pointed out in her statement and her emails to the committee, she has repeatedly expressed her distrust in the neutral functioning of the committee. Despite the committee assuring her that the entire proceedings will be videotaped, this arrangement was specifically made to make the proceedings fair and transparent and reduced to writing and shall be countersigned by her. Another special arrangement was made by the committee to have an independent witness in the whole proceedings to ensure neutrality in the recording of the statements given by the different parties. Despite all such arrangements made and communicated to her repeatedly, complainant showed no faith in the committee. Except for one occasion, recording her initial statement, Professor Mishra neither turned up before the committee with the evidence of witness nor cooperated with the committee. This has also resulted in vestige of man-hours of the committee and legal processes. The committee has otherwise received full cooperation from all parties. The committee recommends that based on the above, necessary disciplinary action may be initiated against Professor Vijay Mishra. Yes. So, from day one,
And just a moment, page 42, please. 4.1.
4.1.
It
Yes.
is, you see, we have to make a distinction between respondent. Please listen to that.
Yes,
If you have not arranged your papers, you should have done it. The moot question which will come for consideration before this court would be that merely because a person is not able to establish her case, does that amount to a false allegation? False allegation, incorrect allegation, not substantiated are totally distinct terminology used in legal sense.
This finds statutory support in Section 14 what your Lordship is saying. Section 14 actually says what your Lordship is saying. Just have
Otherwise, nobody will go and file a
and
complaint.
no one will go and file a complaint.
Because you just see 4.1.
Yes.
Anywhere does it use the term false complaint? False is a very strong word. We use it very sparingly, very consciously. 4.1, please.
Yes, the committee having perused the statement of the complainant, defendant, the witness, and evidence submitted to the committee by the other party, the committee is of the opinion that Professor Mishra alleged sexual harassment against Professor Vera is not substantiated. The committee deliberated and reached to the conclusion that the allegation of Professor Vijay Mishra against Professor Vera is based on the findings of the proceeding and evidence received. The committee finds Professor Vera not guilty of alleged sexual harassment against him by Professor Mishra. The committee has reached to this conclusion after giving enough and uniform opportunities and time all the parties, especially of the complaint, referred to the proceeding in section 2, for her to substantiate the allegation and produce evidence whatsoever. Professor Mishra.
You have read it?
Huh?
You have read it.
So
this
my
is-
submission, two words have been used. A person who makes a complaint, now she does not turns up to support her complaint. For whatever reason.
She turned up, she got her statement recorded perhaps.
Yes. No, that is in the shape of the complaint. Thereafter she should have come. Now she says pleads biasness. That is what my argument includes. We have said that her specific case is that the internal committees were constituted since they heard the abuse which was made by Professor Berat against her.
Just a moment.
Yes.
If the complainant does not appear in the internal committee, if a person who makes a complaint does not appear before the internal committee, what is the recourse? You will still go and find out about the complaint.
No,
Because
we
the
have-
first thing is the complaint,
Yes.
isn't it? But she does not participate.
Yes.
Not at all? She did participate or
She
did
writes
not?
that I am having serious apprehension or biasness against the internal committee, so I will not participate.
All right.
That is what
So-
she says.
Okay. So she.
So once a litigation is triggered under the Act, it is the duty of the management in terms of the Act itself to come to a logical conclusion. Now she has triggered this litigation at 2 points. One before by lodging FIR and the other before this complaint. That is the duty of the head of the institution to get it recorded, because she makes files lodges an FIR and marks a copy to the director. So director requests her, she turns up, her complaint is recorded, and then she pleads biasness against the internal committee on the ground. So the ground what she has said, that the committee should be reconstituted. It is not
What was it? That is not the ground. What was the ground for her distrust on the committee?
that what she says that while she was being abused by Professor Bera in her cabinet, one of the committee members overheard that. So he cannot be there in the committee. So we have to see under the Act how the committee has to be constituted.
No. You see, if a person, he himself becomes a witness to the incident, can he become a committee member? She was objecting to that, no?
She was objecting, yes.
She was objecting to that.
Yes, my submission is that there is no arrangement of it. It is a committee is permanent in nature. That is being constituted.
Suppose there is an allegation against the committee member only.
Hmm.
He will hear the sexual harassment case also against himself. Committees are reconstituted. Special circumstances are taken into
So
consideration.
this management felt that this is not a case of a special circumstance.
Whatever they felt.
Every
But can that become a basis for a dismissal? That is the whole point. We are not on the legality and validity of this
so
finding or
once an
whatever.
allegation has emerged out to be incorrect,
Hmm.
and she herself has not come forward to substantiate her allegation, ultimately, my lord, the underlying principle of the law is that such offence should be dealt with most restricted says, but such things should not happen to be an instrument to harass the other member. Now see the background of the entire case. Her husband participates in the selection process. These all facts have come. See what was the underlying motive for this lodging of the FIR.
We will see what these records are here.
Yes, on record itself I am.
That's right. So
I
now
can
the
tell.
I think I have to clarify one fact, which is the bone of my, the entire edifice of my case. I never approached the committee. That is what I am saying. I merely approached the director and did not request him anything. I made a complaint to the director. The director then forwards it to the committee. Committee on its own asks me. I go and say I don't want the committee. I do not have faith because two of you are present. One external member is not there as per the guidelines. I do not want to participate. So my statement is recorded, and then I don't appear. Then how am I didn't want to go to you? That is my only case. That even the law requires if a complaint is made to the committee, that complaint turns out to be false or malicious, then you are liable.
a person can choose not to.
Not to go. I have chosen not to go, and I have been repeatedly saying I don't want to go because these are the outcomes of this.
And one person was appointed to be present, independent witness. How the committee changed that person in the proceedings? You just see this? Mr. Gunnar. Just a moment, I'll just.
Kanna Prasad, page 33. Page 33 minutes of the compilation, or page 2, para 2.6.
2.6. Yes, Mr. Jayant Tripathi was the independent person who was to be present. 2.6,
Yes,
right?
yes, yes.
He informed that he would be on leave on August 6th. One day he was on leave. On that day, you nominated somebody else, Garna Prasad, as independent witness. Does the procedure go like that?
Madam, what is in terms of the act where it has been violated? My submission is that suppose a person is on leave, a complaint is made, notice being issued, lady has been called on particular date. Now she has to turn up. Now person in the committee says that I will be on leave. So then in that circumstances, what has to be pointed out here, whether this is in breach of any statutory provision. Merely saying so.
You see, there can be so many requirements in law.
Yes.
But the point is that if the lady fails to substantiate her case, does that call for a dismissal?
It also turns out to be incorrect. That does not end at to substantiate. The criminal case also has gone otherwise. So my submission that entire totality of the fact has been taken into consideration while handling this case matter with all sensitivity. What has emerged out
And
because
what did you do to her objection to the internal committee members?
we have said that we will videotape everything.
So how does that make a difference?
So how the bicycle?
No, how does? You see, there are two members in a committee, right?
Yes, yes.
One person is alleged to be biased. He has to prepare the report. Report has to be prepared by him.
Yes.
Even if the entire evidence etc. is recorded, how does that make a difference?
Allegation of biasness and substantiating the biasness, what is the ground of biasness?
You do not say that the allegation of biasness was incorrect. You say that in order to address the allegation of biasness, you got the entire thing videotaped.
Yes.
This is it.
Yes, she says that because one party has heard it, that is also an allegation that he has heard it.
Yes.
Tomorrow I will come with someone and she will say he has also heard it.
Tomorrow.
So where is procedural impropriety, madam? That is I am putting a question to myself. Whether the constitution of the committee is bad one, whether this biasness alleged, this allegation of biasness, whether it is in any way emerging out to be a case of biasness, if the internal committee is constituted, she does not say that he is interested party in. All the more the purpose of internal committee from two within, that they are more conversant with the happening of the things in the environment. It is not that a stranger to the system has been appointed. If law itself prescribes that from within the system 2 persons should be. Now in that backdrop of the fact, if the petitioner is able to make out a case that constitution of the internal committee was bad, finding of the internal committee biasness.
They are making out that case.
They are allegation.
No,
Allegation,
they are.
However,
If a person, you see, there is an allegation,
Yes.
there is a statement of the lady that Mr. So and so, who is a member of the committee, had heard the incident, right? Can he become a part of the committee?
he is not in a litigating process. He is in a fact finding. He is all the more conversant with the unit. He does not say he is a friend of their.
Need not be.
He says the allegation is what he has heard it. Now the requirement of law says that the person from within the system should be part of the committee. Reason underlying.
And if a
that he should be more
person is making any objection with regard to constitution of the committee, what is the stage at which it has to be addressed? What is the stage at which it has to be addressed? It has to be addressed immediately,
Yes.
or it has to be addressed at a later stage at the time of preparation of the final report.
This is what this part is reflected in CAS report, madam. And that is what interlocutory application that all document which is referred.
No, it is here. It should be here only in
Yes,
the CAS
it is
report.
there.
It is there. You
So
tell
these-
us from the report
That document is there.
which document.
This 6th August 2014, the allegation that Vijay Mishra, the petitioner, has written to the chairperson CAS. She says, I am fully cooperating with the investigating team CAS and will continue to cooperate to the best of my ability because I want justice to happen and prevail, which would reduce my mental agony and improve the state of health, physical and mental. A copy of the complaint lodged at Kotwali Police Station. Now, after saying so, then she comes up with the allegation that one member has heard it.
By this time, the committee was constituted.
Yes, yes.
No,
All correspondence is there. That is what my lord.
I filed a before that. 5th August I lodged a complaint, the 2 members have heard it. 6th I make this complaint, and moreover section 7 violation, the independent member is a person who is from an NGO or an organization who deal with women affairs. they got someone from the next institute. So that also I have said, section
Who,
7.
who was this person? From
This-
which institute?
From they have got it from BIT.
BIT.
And we said that she is not a person who qualifies in terms of section 7C. At least one of whom shall be women to be nominated among such non-governmental organizations or associations committed to the cause of women or person familiar with the issue related to sexual harassment which may describe. So we raise that also, that who is this independent member? How does he qualify this?
And one of the witnesses did not appear. This
I only feel
Padini, Mousumi Padini, I think perhaps did not appear. One of them did not appear, I think.
So what I say that on
Just a moment. Professor Bera is the accused,
Yes.
right? Then Professor Sibashish Chakravarti is the witness, right? And Professor Mosmi Padhi is another witness. One of the witnesses perhaps did not appear. Is that so? Did she appear? I think one of them did not appear.
So two witnesses from were examined.
That is one is the accused himself.
So then total 4. Professor Bera the accused.
Okay.
Then one is Professor Anand, one is Professor Shivashish Chakravarti, and one is Mrs. Swati Kindo, which is evident from para 2.8, page 35 of my compilation. Or internal page 5 of the report.
You just see page number 80, 80 of the main petition.
Of the
Yes, sorry, page number 30 of your compilation.
yes.
This is
So these are the list of witnesses given, but Moshmi Pari never came. Sadasir Bera was examined and Shivashish Chakravarti was examined.
yes. So one did not come.
Did not appear, was never summoned. In fact, that was changed. That's what I was requesting you to see. This page, internal page 5 of the report. On 14th August, kindly see page 35, page 2.6. On August 14, 2014, the committee received a letter from Professor Bera requesting to examine the witnesses, Professor P.K. Bala, Professor Anand, Professor Shivashish Chakravarti, and Mrs. Swati Kindo, named by Professor Vijaya Mishra in our statement. Letter from Professor Bera to carry well. The committee then informed Professor Bala, Professor Anand, Professor Shivashish, and Mrs. Swati Kindo, and Mr. Khanna over email to be present on 18th August. On August 18, 2014, Professor Bera handed over a set of questions for each of the witnesses mentioned in 2.7 above. The committee examined the questions and whether it could be allowed or disallowed as outlined in the policy document. Policy document to be present, so and so. The committee decided to allow the submitted questions and the committee proceeded to ask the questions of the witness in the presence of Professor Bera, the independent witness. The entire proceeding was also videographed and reduced to writing. The questions and responses are provided.
All right, that's all.
So there were 3 witnesses.
After this fact-finding committee, you say that even if it is not substantiated, still nothing could be done against you
Section 14.
in terms of section 14.
I-
Let us see section 14.
14. That is the basis of this initiation. Kindly see section 14. Where the internal committee or the local committee, as the case may be, arrives at a conclusion that the allegation against the respondent is malicious, or the aggrieved woman or any other person making the complaint has made the complaint knowing it to be false, or aggrieved person or any other person making the complaint has produced false or misleading document, it may recommend to the employer or the district officer, as the case may be, to take action against the woman or the person who has made the complaint under subsection 1 or subsection 2 of section 9, as the case may be, in accordance with the provisions of service rules applicable to him, or where such no service rules exist in such manner as requested. Now, provided that mere inability to substantiate a complaint of provide adequate proof need not attract the action against the complainant. Provided further that malicious intent on the part of the complainant shall be established after an inquiry in accordance with the procedure prescribed before any action is recommended. So here are two things. You have come to a conclusion while entertaining my complaint, which I deny, and then you say I have not been able to substantiate it is incorrect. But number one, it is not. There is no finding that it was malicious. They may say that you knew it to be false. I say no. I never knew it to be false. I may not. There is a difference between not knowing it to be false and not able to substantiate. So therefore, his recommendations at the conclusion itself is inconsistent. Based on this, please kindly look at the show cause notice which was given to me.
Just a moment. This second proviso also you know.
Second proviso.
That is also an important exercise.
My lord. That it has to be done separately in that
Separately,
proceeding.
in that
means I
proceeding.
must be put to notice that this is fact finding we are doing now.
Yes.
It was
Whether
malicious
your
or-
intent was malicious or
Malicious.
not, or whether one of these ingredients are there or
Yes.
not.
So maximum errors taking the most liberal interpretation is that knowing it to be false. If
That's
I say
right.
incorrect
Maximum.
is knowing it to be false. They have been arguing.
Incorrect is, you see,
No.
false and incorrect are two different words altogether,
Absolutely.
and they have different connotation altogether. And in English literature, both, that is why we very sparingly use word false in our orders also, unless we are really required to use. We always use the word incorrect. Incorrect may be because of n number of reasons. False has an intent. Incorrect may not have an intent. There is a difference between the two. And this inquiry has been done?
No.
Yes, explain 14 second proviso. Has this inquiry been done? Straight to the point of law, you just come straight. Has this inquiry been done or not done? I think this will clinch the issue. That's it. You answer this, you get your order. You just tell us.
This, I have to.
No,
Yes,
no,
recommendation.
no, please no. We have
There is
had enough.
recommendation, next week I will not respond to that.
No, you
Because
don't
this
need to. You see, we are not going to adjourn it on this. You straight away answer this.
So this fact was taken into inquiry itself and show cause notice because he declined to participate, so finding was there. If we read the cash report, let me place it.
Yes, please place the cash. Apparently that inquiry was not done because it is there in the cash report itself. The recommendation for taking a disciplinary action against the petitioner is mentioned in the cash report itself. So no separate inquiry. For that you don't need to seek any instructions.
Because my record, the point matter because the file has traveled n number of times. So I am not having that fact on record, but I cannot make a statement to that effect. But
Adjournment rejected.
No, this is evident from the annexure 8, the show cause notice, what procedure was followed. The show cause given to me after the inquiry, page 24 of my compilation. I want you to see this also. This is January 8, 2016.
Yes, please.
Kindly allow me to place this now. A complaint dated 24/7/2014 was received by the director IIM stating that Professor Sadashiv Bera of IIM has harassed you sexually. IIM Ranchi, being the employer, constituted a committee to investigate the matter as per provisions of so and so to the charges as leveled against you by so and so. You know, the said committee received a copy of the complaint dated filed by you against Professor Sadashiv Bera accusing of so and investigated the matter. Wherein, after being an ample opportunity to review and after making proper inquiry, the committee concluded that the allegations of sexual harassment leveled by you against Professor Sadashiv Bera is not substantiated. They also concluded that the allegations leveled by you against Professor Bera are not correct. Now let me stop here for now. So there is no separate inquiry, it's only talking about one
That's
inquiry. Now, the finding of the committee is as follows. The committee having perused the statements of the complainant, Professor Vijay Mishra, defendant so and so, the witnesses and evidence submitted to the committee by the above parties, the committee is of the opinion that Professor Mishra's alleged sexual harassment against Professor Bera is not substantial. The committee deliberated and reached to the conclusion that the allegations of Professor Vijay Mishra against Professor Bera are incorrect. Based on the finding of the proceeding and evidence received, the committee finds that Professor Bera not guilty of the alleged sexual harassment against him by Professor Mishra. The committee has reached to this conclusion after giving enough and uniform opportunities and time to all parties, especially to the complainant, for her to substantiate the allegations and produce any witness. The allegations made by you against Professor Sadashiv Bera have been found to be false by the police authorities by final form dated so and so. This I will answer. Now, In the background of the above inquiries and conclusions, it is evident that you had made a false and malicious complaint against Professor Sadar Bera.
On the basis of a police report?
No, but where is the malice? The committee also does not say malicious. The show cause says it is malicious. I say, how have you? And my lords, it is a conclusive show cause that you have. It is evident that you have made a false error. The High Court judgment of the Supreme Court says that these are predetermined show cause notices.
No, and this paragraph number 6 is on the basis of para 5.
Yes, para 5. Para 5, what happened? Police submitted final report. I filed a protest. It was dismissed.
That's
I came before the High Court. High Court had remanded the matter.
So we are not on that, but still, this particular show cause is not confined to the committee report.
Not committee report. Beyond that, and it is adding malicious. How have they added malicious? Malicious is not within the finding of the committee. So this is there was a predetermined inquiry against me.
Page 98 of my this petition.
And this particular inquiry,
Yes.
Second proviso to section 14,
Yes.
has to be made by the sexual harassment committee
Committee.
itself,
For
not
the-
by anybody else.
No, for the purpose of making a recommendation.
That's right.
It says.
So this show cause is not preceded by any inquiry by committee,
Cash.
by cash. So that stage is totally missing.
Absolutely. So your lordship is right. I missed this point. So it is without jurisdiction. The recommendation itself is without you. You have to make a separate inquiry, a small inquiry, but an inquiry.
We cannot let loose the female in this manner.
Page
No,
98
today,
my
the position
petition.
is, today the position is, I'm sorry, I'm interrupting, the
Yes.
factual position is that my client has lost her job. And the problem is when you lose a job because you say, it has been said that you have made a false complaint of this nature, it has taken a toll on her health.
Must have.
It has taken a toll because the society looks at her and they also, the entire institution, oh, you are fighting it for your husband because your husband was not promoted. Where is the allegation? Why is my learned friend also arguing that? This is the instruction in their mind. So everybody is saying your husband used you.
Now, Mr. Pallav,
Yes.
right? You forget about your client, you also forget.
No,
about
we are.
You just tell us.
Yes, yes.
Second proviso is mandatory or not mandatory? And where is the exercise of second proviso?
That is page 98 of the writ petition. It's
98.
Yes.
Okay. This is by cash.
They have a kind of this.
All right. Page 98.
The director has issued this.
Director has no business to issue it. This inquiry has to be by cash. Because the recommendation has to come by cash.
So, my lord, what I am looking into the facts, my lord, to formulate this particular issue.
I have already
Okay.
formulated and
Because
I have no
this
doubts in my
inquiry-
mind.
This inquiry, it says my lord 14, so there must be a recommendation. So I am submitting, now section 14, if I just press it, my lord, appointment of inquiry officer in relation to Department of Proceeding initiated by the office order dated 22nd April 2016, serving memorandum in connection to the provisions of section 14 of Central Civil Criminal Classification Rules 1960. So this is how it has proceeded. Section 14 of the Civil Service Code.
You just see the cash report, right? Cash report says not substantiated, incorrect, and straight away disciplinary proceedings. Where is the inquiry second proviso?
My lord, the entire text has to be read in context.
No, no.
Preceding fact.
No,
word
it's
cannot
a
be
very
borrowed
important exercise.
No, I write it correct. The background picture cannot be written off. The entire document has to be. If I cannot read it in isolation.
There is no separate inquiry on this. There is no inquiry on this. There has to be a separate inquiry. Section 14 is a very serious thing. This is the protection to both the parties, right?
Yes, yes.
Yes. And you see the kind of words that are used in section 14, where the internal committee or the local committee, as the case may be, arrives at a conclusion that the allegation against is malicious, or the aggrieved person, a woman or any other person making the complaint has made the complaint knowing it to be false, or the aggrieved woman or any other person making the complaint has produced any forged or misleading document, it may recommend. Only under these circumstances, and there is a clear-cut indication in section 14 itself that merely because a person is not able to substantiate her allegation, that will not be a ground to proceeding under section 14.
That is the principle of.
It's open and
And
shut.
there is no dispute, but here it is.
Let's have some judgment, no, where there is no precedence.
That is the minority's quota of report to 15. It's always binding, but I want to explain the full assistance on the
No, I'm hearing
what
you
I
for
was-
last half an hour.
No. The assistance Miss Marriott, there are certain readings are missing,
No, please
answers
don't.
are missing,
No,
questions are
no,
coming
no,
up.
no.
So my point is that we have formulated the supplementary, we have given this one aspect what has been raised in the recommendation. Now it is coming that whether 14 recommendation was made to for
It is on the face of it, there was no inquiry on that. Because the cash report itself is recommending. There is no separate inquiry. Apparently. Apparently, there is no separate inquiry.
separate inquiry, that is page 98.
By
Yeah.
cash.
So that document may be proceeding because that recommendation thereafter a full-fledged inquiry under 1400 has to be.
Nothing, it's not there on record.
So my submission was limited to that effect. I am not running away from the adjudication of the matter. Because
You
if
are-
certain
Time is running against the petitioner. You want her to retire?
1 week, I don't think that next week is the return.
For so many adjournments you have taken.
No, I have not taken. I may see the report.
No, but
Some,
I'm sorry.
I have taken some adjournment.
I'm sorry. Kindly have a look at order dated 4th of May 2023. The request was rejected.
Yes.
So
And thereafter my lord said that other orders also. I was present. My lord, let us not make allegation.
No,
against
I'm
us.
not making any allegation. I'm just
So
saying
we are here for some reason. Sometimes you did not appear.
no, it's not about that. Kindly allow.
I am not adverse because factual issues are coming up. There is no recommendation. Suppose tomorrow, if there is a recommendation, again review application will come in absence of that. I want a full-fledged
Lordship,
assistance on fact. My lord, point out this as a question of law next week. We don't need to file it. On instruction we can give.
Your Lordship have said that no other plea which is already on record will be permitted to be taken, including alternative remedy. So I'm just bringing to your Lordship's notice that there is an
So
order.
today it has emerged out whether section 14 CAS has recommended for disciplinary action under 14 or not. This is a factual point. If not, then this is a strict law. It has to be given a strictest interpretation and therefore the entire proceeding will be shared. But if that there is a recommendation on the part of the department, then we can just take instruction and even if not required to file. As an officer of the court, I will make a statement to that effect.
Can I also assist your Lordship and request your Lordship to see section 13 for a moment?
Yes.
It is very important. Section 13 is the inquiry report. On completion of the inquiry under this act, the internal committee or the local committee, as the case may be, shall provide a report of its finding to the employer, or as the case may be, the district officer within a period of 10 days from date of completion of the inquiry, and such report may be made available to the concerned party. Where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the respondent has not been proved, it shall recommend to the employer and the district officer that no action is required to be taken in the matter. Now, where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the respondent has been proved, it shall recommend to the employer or the district officer, as the case may be, to take action for sexual harassment as a misconduct in accordance with the provisions of service rules applicable to the respondent, where no service rules have been made in such manner as may prescribe. To deduct notwithstanding anything in the service rules applicable to the respondent from the salary or wages, the respondent such sum as it may consider appropriate to be paid to the aggrieved officer or a legal heir as it may determine in accordance with it. Provided that in case the employer is unable to make such a deduction from the salary, the respondent may due to so and so, so and so. Provided further that in the case the respondent fails to pay the sum referred in clause so and so, or the internal, as the case may be, local authority. So why I read it now, last is 4. Why I read it is the inquiry report after conclusion of the inquiry in terms of section 13 can only specifically recommend don't take action or take this action.
That's
Therefore, when we give the second proviso to section 14, it means a separate report, separate inquiry.
it has so much of meaning embedded in it. It has so much of meaning embedded in it.
There is no dispute about it.
Then
Point is that whether recommendation was made or not.
there is no recommendation
It is made, but in a same inquiry.
in the same inquiry. There is no separate inquiry to that effect.
The inquiry is separate. It will make a recommendation to the employer. Employer then will take
They will make a recommendation to the employer if he is found guilty.
Yes.
Yes, if he is not found guilty, the consequences is at section 14.
So here it is found.
And therefore a separate inquiry is called for. If that female is unable to prove the allegation, right, then under such circumstances, by default, she will not be dismissed. There has to be a separate inquiry to that effect.
That inquiry is there. What
No,
recommendation
that
part is there?
no. That inquiry that the allegation was vexatious, there has to be a separate inquiry to that effect under section 14.
Because it is very simple, no? Because I am going to present my case. I am not going to defend my complaint.
You see, provided further that the malicious intent or on the part of the complaint shall be established after an inquiry in accordance with the procedure prescribed before any action is recommended.
May I read it once more? Where the internal committee or local committee, as the case may be, arrives at a conclusion that the allegation against the respondent is malicious, or the aggrieved woman or any other person making the complaint has made the complaint knowing it to be false, or aggrieved woman or any other person making the complaint has produced any false or misleading document, it may recommend to the employer or the district officer, as their case may be, to take action against the woman or the person who has made the complaint under subsection 1 or subsection 2 of 9, as the case may be, in accordance with the provisions of service law applicable to her or him, or where no such service law exists, in such manner as may be prescribed. So 14 just it says.
Kindly pause. Any of the ingredient which has been specifically mentioned in section 14 is not there in the inquiry.
Yes.
Right? Malicious, not there. Right? Forgery, not there.
Misleading.
Just a
Misleading
moment.
document.
Misleading documents. ठीक है?
Misleading document.
There are three things. One is malicious. Other is
Knowing it to be false.
knowing it to be false, or any other person who has produced any forged or misleading document. Right? These ingredients are not there in your cash report at all.
Two things emerges out what I was trying to submit, because two issues have been diluted. That independent inquiry is also to be carried out in 14. In that respect, I am submitting that CAS can straight away after coming to finding can make recommendation. And then what is to be followed, that employer under the applicable service rule has to take action. No independent inquiry under 14 is prescribed. Now, second aspect which my lord is pointing out, that CAS committee has never said it is vexatious, force, or whatever the terminology is used.
That's right.
To that is effect, my lord, because my lord is exercising jurisdiction under 226.
Therefore, I will see the law.
So
Therefore, I will see the law.
yes. So entire background of the case which is there in the CAS report, the entire fact, what my learned friend said, that from where I am saying husband, if I read the entire report, things will surface upon its own. I have not to refer anything else.
That's right.
So the point is that what is being said incorrect in here, if looked into the context of the entire, because ultimately to understand a degree part, the judgment has to be looked into.
Is there any finding of the inquiry report in the cash report that she, in order to help her husband in such and such manner, had done it?
What fact has come
No,
with the evidence?
fact and finding are two different things.
Based on that, it has that her
There is no
complaint
finding.
incorrect.
There is no finding
Her
to that.
allegation is incorrect, it has been said, she has made an allegation, and preceding fact, that's how my lord, only thing that has to be read is the CAS committee. The only thing that has to be read. So I am not, my lord may not take it.
And the show cause, and in the show cause,
Yes.
you not only refer to the cash committee report, but also refer to the criminal case where she was not able to substantiate. If a criminal case is filed and the person is not able to substantiate her case, then dismissal proceedings will be initiated against her. Both the elements are there. The show cause is not based only on the cash report. It is also based on the fact that she was not able to substantiate her
Service
case.
rule never confines to that. There are other allegations also. We need not require to segregate that for CAS it will be this, then again for C has triggered the criminal litigation.
So,
There is a complete investigation. Investigation says whatever may be the state, her FIR is there, and one investigation says it is a false.
any case under filing false case has been initiated against her.
No, that is not.
Has that been done?
No, that has not been.
That is not. That is
Because
also
the
a
matter is-
procedure.
because there was a revision, probably
That-
the matter has been remanded.
That
So,
procedure is also prescribed under law, that if anybody files a false complaint, false FIR, then the police has a right to prosecute that
Under
person.
182(211), that is there. But for that, the cause of action has not matured. The matter is remanded again, it is before the first court.
That's right.
So, unless the cause of action, once it will be a clear denial, then it is a liberty in the hand of the person aggrieved. So, my submission
that's
is that separate inquiry and the court is not required.
Okay, just a moment, I'll just note your arguments. First, second proviso inquiry is not required.
So that
What else?
Madam, based on the pleading, I have formulated these issues and I have responded to them. My learned friend had made in his pleading that I have never made a complaint before law. To that we have responded that section 9(1) asks a duty on the employer that to get the complaint registered, and that was duly registered. That is the first point, madam.
Okay.
I have filed
Just
my-
a moment.
Yes.
Suppose a complaint is made and to the employer and he sends it to cash, right? But the person does not want to pursue it. Has, you see, under the cash,
Yes.
then when the matter is referred to cash, then under such circumstances a formal complaint is also made before cash as per the procedure, as I remember.
Section 9.
Section
nine,
9.
I will think.
Has any formal complaint been made
Yes,
before
that
cash?
is reduced down. That is 5th August. She was called and that is reduced down. Let me read out my section 9. What does it say? 9. Any aggrieved woman may make in writing a complaint of sexual harassment at a workplace to the internal committee if so constituted, or the local committee in case it is not so constituted, within a period of 3 months from the date of incident, and in case of a series of incidents within a period of 3 months from the date of last incident, provided that where such complaint cannot be made in writing, the presiding officer or member of the internal committee or the chairperson or the member of the local committee, as the case may be, shall render all reasonable assistance to the women for making the complaint in writing, provided further that internal committee or the case may be, the local committee may, for the reasons recorded in writing, extend time limit not exceeding 3 months if it is satisfied that the circumstances were such which prevented the women from making such complaint. Here, she makes a complaint before police station, marks a copy to the director.
Please do. You just, as per section 9, the complaint has to be made to the sexual harassment committee.
Yes.
The lady is not an illiterate person, right? Nor she is mad, nor she is handicapped, right? She is a conscious, educated person, right? She does not make any complaint to the sexual harassment committee. Okay. Then how do you say that the complaint was ever made to the sexual harassment committee? On which clause are you referring to of clause
That
9?
it is provided that the internal committee, as the case may be, here, provided that where such complaint cannot be made in writing.
Yes.
So she has not approached
No.
me, first instance.
Such complaint cannot be made in writing means?
Means she has not chosen to make the complaint.
No. It's not one and the same thing. How do you say that it cannot be made in writing by her? She doesn't want to pursue it. She doesn't want to file a case before the sexual harassment committee. She did not file it.
No, thereafter when she marked a letter to me, that yes. I am
Since you
present.
are issuing notice, she has no option but to mark a letter to you.
She writes a letter to the director.
Yes.
Director forwards it to the committee. Committee issues notice. She comes forward and get her complaint written before the interview.
Where is that written
Yes.
complaint?
That is.
Where is it?
Page 80.
This is not in their. This was actually in part of their IA. This is this one.
Exhibit 5 is to the class committee. This is marked as exhibit 5. Now, once we receive.
Where is her complaint?
Madam,
I want to see the complaint.
Yes, madam. This is to the member of the caste committee. I am where present where with the
Sorry.
yes.
Kindly come to page 13. What your worship is asking is kindness.
Page number?
Page 13 of this IA. They have filed.
It is that IE.
IA. They have filed notes for
Yes, IE. Page number 13.
Kindly first take that. 30th
Okay.
July letter.
Hmm.
Director in charge is writing. This is from. Although no written or verbal complaint has been given by Professor Vijay Mishra regarding
Yes.
although no written or verbal complaint has been given by Professor Vijay Mishra regarding sexual harassment by Professor Sasadar Vera to the administration department, a number of newspapers have reported that a complaint has been filed by Professor Vijay Mishra against Professor Sasadar Vera, Kotwali Thana. A copy of the police complaint is attached here. In view of the above, I would recommend that Sexual Harassment Committee of IME investigate the matter and give out its report to you as Director so and so.
You just tell us one thing.
Yes.
When a criminal case is filed, right, and no complaint is filed with the management, and only a copy of the criminal case is forwarded, then the management will start investigating the matter and prepare a report. Or a regular complaint in terms of section 9 is required to be filed by the aggrieved woman before the cash committee.
In my understanding, if the management is made aware of the thing,
So they
it is
will
duty to
show
get
us
it.
under which provision of law.
Section 9.
Section 9 does not say that if anybody comes to know about any sexual harassment, then the cash will take
To
its.
get it, you can.
No.
It says,
On a
that
complaint.
where such complaint cannot be made in writing, the presiding officer, or member of internal committee, or the chairperson, or the member.
Cannot be made in writing. How do you impute this to the
Now she
petitioner?
comes forward. This she has waived her rights. She has come forward. She has come forward. She has said that.
Waived?
She has-
You are pleading waiver?
She has come and she has participated. She says that I am.
You say that
to
you did
cooperate.
not. You said that she did not participate. Now you say that she came forward and she has waived her right to object to the committee.
Two stages. What I am saying, Violet, I am not contradicting. She says that I will cooperate with the caste committee. Then she says that I am not happy with one of the member of the caste committee. So she never says that your constitution is bad. She says that you please reconstitute the committee. So the case that stands on here is that whether there is any procedural impropriety in constituting the committee. She cannot take this plea that no, I have not made a complaint. She has come forward. She has given her communication to the management with the objection that I don't want to participate in this committee to the extent that one of the member is, I am having objection and bias will come. So on factual aspect, that is what is settling down.
So
in this.
or-
So that is all my summation, and my written notes will be taken into consideration.
Okay.
Because based on whatever pleading is there, this is filed on 14th of June 23. So I don't want to, this is the facts, I cannot add or subtract.
Tell me that.
I
14
have
June
filed it,
23.
madam. I have filed it.
देखिए मैं उनका written submission कहाँ है? 14 June 23.
14 June.
ये बात।
You say section 14 does not apply
Huh? No, that is
in your written submission.
no, it is my submission.
Central government. Cash, therefore section 14 of the act does not apply.
Acha, never I said the-
Here it is being
Mine
claimed
is
that
14
cash
June.
was not as per the provision of section 7 of the Act of 30.
ये मेरा note.
ये क्या submitted by Central Government Council.
Those are the answers. I had raised 4 issues. Heading they have given the answers to those. I have raised 4 issues.
So we, because of that manner, we are.
Where
trying-
is your 4 issues?
What?
कहाँ है आपका 4 issues?
मेरा complaint, मेरा written notes.
Seems on the written notes.
मेरा written note इस तरह का होगा.
देखिए, learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner never made any complaint in the Committee of Sexual Harassment,
Committee
within
is sexual
bracket
harassment.
cash, and only a complaint which was lodged with the police.
Police.
Only a complaint was lodged with the police, and a copy of the same was forwarded to the director, who suo moto
Yes.
referred the matter to cash.
From cash.
The Learned Counsel has also referred to page number 13 of IA number 5183 of 2023, which is a letter dated 30/7/2014, and submits that it has been specifically mentioned therein that although no written or verbal complaint has been given by the petitioner regarding sexual harassment by the private respondent to the administration department, but a number of newspapers had reported that the complaint was filed by the petitioner against the private respondent in Kotwali police station. And in view of the same, a recommendation was made to Sexual Harassment Committee of IIM Ranchi to investigate the matter and give out its report to the director, IIM Ranchi, at the earliest. The Learned Counsel further submits that when notices were issued by cash, the petitioner had strongly objected to the constitution of the committee, inasmuch as she alleged that one of the members of the committee had overheard the altercation with the private respondent.
Two members, miss, two members.
Two members.
Yes, Tanushree Datta and Professor Amrendra Nanda. Page 26 of that IA, if you look for committee.
Two members of
The committee
the committee.
were present.
The Learned Counsel has referred to page number 26
He said,
of the interlocutory application,
which is a letter.
whereby the objection was raised.
Not only that, in the said letter, it was also said that I was forced to give my statement, though I resisted it. There also I've said.
The Learned Counsel has also submitted that in the said letter, the petitioner had also stated that she was forced to give a statement also. She never wanted to do so.
Because she had already represented against the neutrality of cash.
Because she had already objected to the constitution of the committee. The Learned Counsel further submits that the cash committee report recorded that the petitioner could not substantiate the allegation made against the private respondent, and also that the allegation was incorrect, but the same by itself would not have called for any proceeding against the petitioner, any disciplinary proceeding against the petitioner, inasmuch as the required inquiry in terms of section 14 of the Sexual Harassment of Women at Workplace within bracket Prevention and Prohibition of Redressal Act 2013 was required to be done. He has submitted that as per the first proviso of section 14 within bracket 1, it has been made clear that mere inability to substantiate a complaint or provide adequate proof need not attract action against the complainant under section 14. For it, he also submits that in order to proceed under section 14, the second proviso to section 14 within bracket 1 provides further that malicious intent on the part of the complainant shall be established after an inquiry in accordance with the procedure prescribed before any action is recommended. The Learned Counsel submits that no exercise in terms of second proviso to section 14 has been undertaken, and the same is apparent from the fact that the cash report itself had recommended for taking action against the petitioner. The Learned Counsel has submitted that the inquiry in terms of second proviso is a condition precedent for taking any action against a person who upon inquiry is found that the case was malicious, that the complaint was malicious, or the complainant knew it to be false, or the aggrieved woman or any person making the complaint had produced any forged or misleading document. The Learned Counsel has submitted that it was a simple case where the petitioner could not substantiate her allegation against a private respondent, and accordingly the entire proceeding initiated against the petitioner is vitiated and is void ab initio. He has reiterated that the proceeding is contrary to the procedure prescribed under section 9 as well as procedure prescribed under section 14. This is over and above the fact that that allegation of bias was made against the committee constituted under cash. That's all.
Yes.
The Learned Counsel.
Though I also wanted to take up two more points, like just your Lordship has page 5 of my note. That the final form by the police was not a relevant factor in the ultimate discipline proceeding. This is also a factor. The final form by the police could not have been a factor for imposing punishment.
Okay.
Number 2, that the proceedings, the disciplinary proceedings were conducted in an unfair manner because the show cause itself was predetermined.
Okay.
The page 5 has set out ground
Yes.
number 2, 3, and 4.
The Learned Counsel has referred to the following grounds for consideration. He has submitted that the show cause itself referred to the filing of the criminal case, which had no bearing in the matter of disciplinary proceedings.
And it was predetermined because it added malicious, that I am guilty of malicious.
Yes, the Learned Counsel has also referred to the show cause to submit that the show cause itself was issued with a predetermined mind. Show cause is at page number?
Show cause of no convenience compilation, you should find at
Show
page
cause is
Yes,
at page
121
number
annex.
24 of the convenience compilation.
It's page number 100.
24 of the convenience compilation. 8th January 2016.
Haji.
Right? Yes.
Eight
Now
January.
your submission I am writing.
Yes, sir.
Can I get
Fine. The Learned Counsel appearing on who is for the private respondent, he has chosen not to appear perhaps.
he's not.
Okay. Notice was issued to him.
No, madam, because I was entered in the file at the very letter.
आपको doubt मतलब क्या? You don't inspect the records.
No, I have-
Whenever you enter into a new case which was already running, what is the first thing you have to do? Inspect the record.
ये सब हो चुका है.
हाँ, हो चुका है, remember
Notice
हो
has been
चुका है.
validly served. However, is there not a put his appearance?
Yes.
One more opportunity was granted 5-3, and then we
Okay. The records of the case indicate that the notices issued to the private respondent was validly served, but nobody has entered appearance on behalf of the private respondent. The Learned Counsel appearing on behalf of the other respondents has vehemently opposed the prayer of the petitioner and has submitted that the scope of interference in the matter of disciplinary inquiry is very limited under Article 226 of the Constitution of India. The Learned Counsel has also submitted that the required procedure has also been followed in the present case. Therefore, there is no procedural lapse. The Learned Counsel, while answering to the point raised by the petitioner in connection with Section 9, has submitted that the petition Section 9 has submitted that the petitioner had appeared before the Sexual Harassment Committee once.
The director received the
Yeah,
copy,
okay. Once the director received the copy of the criminal case,
complaint made before the police.
complaint made by the petitioner before the police, it was incumbent upon the director to refer the matter to
Okay.
Sexual Harassment Committee, which was duly done.
And the committee put the petitioner to notice.
And thereafter the notice was issued to the petitioner. The petitioner had appeared and got her statement recorded.
Yes.
And thereafter she refused to appear before
Then
the
thereafter
committee.
she said that she will cooperate with the cash, but she doubts the
Okay.
independence,
Thereafter, she
neutrality of the
said.
committee.
Thereafter, she had stated that she would cooperate with the proceeding, but she had objection with regard to constitution of the committee.
To which the committee had stated that everything will
Okay.
be.
In order to address this grievance of the petitioner, the committee had ensured that the entire proceeding is recorded through video. And
And there is
the same
no,
having been done, the petitioner cannot have any grievance with regard to the fact that the committee was neutral.
and there is no provision for ad hoc committee to case basis constitution.
Okay.
Internal committee is a permanent
The Learned Council has also
Yes, sir.
submitted that the internal committee is a permanent committee, and merely because one or the other person had heard the altercation, the same does not call for reconstitution of committee.
unless specific biasness is proved. Over here, she says that because he overrode, so there is biasness. So this cannot be by a ground for biasness.
And merely because one or the other person had overheard the altercation, the same cannot be a ground to say that the committee was biased.
Under section 14,
With regard to, however, it is not in dispute that no verbal or written complaint was made by the petitioner before the sexual harassment committee. That is there in your record only. In IU you have filed it.
she got her statement recorded on.
That's right, I have recorded that. Yes.
On
With
her
section-
own.
With regard to section 14,
Yes.
the Learned Council for the
Cash
respondent
Yes.
has submitted that the necessary inquiry was already done by the cash.
The inquiry was done by the cash and recommendation was made, and the section 14 prescribes that the employer may take action against the woman or the person who has made the complaint under section 2 as the case may be in accordance with the provisions of service.
Okay.
So the cash report made a recommendation, and thereafter the applicable central services rule which is applicable to
Okay.
them, we have taken action.
The Learned Council has submitted that the cash, in its report, had clearly, after having held that the allegation against the private respondent was not substantiated, has also recommended for action. And not substantiated and was incorrect, and has also made a recommendation for taking disciplinary action against the petitioner in terms of the service rules, and therefore there is no violation of section 14 of the Aforesaid Act of 2013.
Lastly, the entire cash committee report is extensive on the point of the fact that incorrect can be very much reduced as malicious.
Okay. The Learned Council has also submitted that the cash committee report should be read as a whole, and the incorrect allegation which has been found can be read as malicious.
Was actuated with malice.
Was actuated with malice, and therefore the complaint was tainted with malice from the side of the petitioner. Therefore, there is no procedural irregularity in the matter. This case does not call for any interference.
It suffers from vice of jurisdiction.
What jurisdiction?
Means they have said that because committee was not properly constituted, independent member was not there, or that for that reason, it is by submission that in absence of a complaint it could not have been proceeded. So it does not suffer from
Okay,
vice
the
of
Learned
jurisdiction.
Council has also submitted that there is no jurisdictional error in the entire proceeding and the final order which are impugned in the present case. That's all.
That's it.
Tell you. Arguments concluded. इसको एक तो डेट दीजिए जजमेंट की, जनवरी का डेट दीजिए तो कोई post for judgment on 30th January. नेक्स्ट कॉल कर।
केस करे 3 बजे
हाँ, एक केस 3 बजे कौन सा था, किसका था?
आइटम 23 आइटम 23 केस CRMP 3491 of 2023
Yes, you are there. What happened? You want extension of time?
Because extension also, and one of the petitioners who has been arrested. It was heard, and
How many petitioners were there?
two
Who has filed the petition for extension?
both of
Both of them. All right. What was the time period prescribed?
Not 2 months.
When did it expire?
From the date of communication of the judgment.
When was it communicated?
Because that fact we don't have. Though the time is much greater, because the order is dated 8/3/21.
Hmm.
तो 2 साल तो से ऊपर तो हो ही गया.
जो अरेस्ट हुआ वो कब अरेस्ट हुआ?
He has been arrested. Next the order.
17/10/23.
17/10.
17/10/23.
10/20.
जो डिफॉल्ट का हम उसका दिए हैं उसका क्या करें?
But we have taken a ground because that they were working outside during COVID period. It could not be communicated to them. That is the reason.
Meantime, there was COVID. CRMP number 3491 of 23. Where is the state? APP कोई नहीं है? नहीं, बुला के लेके आइए, ऐसे कैसे कर सकते हैं? Call him please. Who is there on record? कौन थे? विश्वनाथ रॉय. ये तो अभी होंगे हाईकोर्ट में, अभी जाते नहीं है 4:30-5 बजे के पहले. बुलाइए, उनको बुला लीजिए प्लीज, हम कर देंगे, बट हिज प्रेजेंस इज रिक्वायर्ड.
Item 3 WPS 6351 of 2018
आइटम 3 क्या है?
undisclosed.
क्या मैटर है? क्या है इसमें? नो वर्क नो पेमेंट. व्हाट इज इट? Counsel for the parties are present. Counsel for the petitioner seeks adjournment. Close this case on next Friday. No further adjournment will be granted. Next.
For orders with defect, item 4 CMP 506 of 2022.
कितना टाइम चाहिए?
ये सप्ताह दे.
Time till 19th of January 24 is granted to the petitioner to remove the surviving defects preemptively. If the defects are removed within the stipulated time, 3 हफ्ता चाहिए ना, 12 तारीख तक, 12th of January. If the defects are removed within the stipulated time, post this case on 19th of January. Next.
Item 5 CMP 514 of 2022. Defect.
Same order. Petitioner absent.
Item
आप हैं
6
respondent? In this case? In this third, fourth case?
item 5.
हाँ. इनका memo of appearance दीजिए.
Item 6
नहीं तो
CMP
appearance record नहीं होगा आपका. You better give. Yes.
Item 6 CMP 801 of 2022.
Same order, give your appearance.
Item 7, CMP 901 of 2022.
CMP number 901 of 2022, counsel for the petitioner seeks permission to withdraw this petition. Permission is accorded. This petition is dismissed as withdrawn. Any objection? Counsel for the respondents has no objection to the prayer made. What is your name? Arun Kumar Gupta. ठीक है? Sign करिए.
Item 8, CMP 1103 of 2022.
Yes, petitioner. Same order. Same order. You remove the defects. Preemptory order and that's right. Whatever it is, you if that case is defect free by 12th of January, it will be listed on 19th January. Otherwise, there is a preemptory order. Still.
Item 9, CMP 1104 of 2022.
Petitioner. Same order. Respondent absent. Mohammed Hatim for the petitioner. Restoration कौन स्टेट नहीं है क्या? कौन है? प्राइवेट पार्टी है. स्टेट को सर्व किए होंगे ना आप? बहुत अच्छी बात है. नहीं किए. डिफेक्ट में ही डिसमिस हो जाएगा. फिर रेस्टोरेशन का रेस्टोरेशन फाइल करिए.
Item 10, CMP 307 of 2023.
Yes, petitioner.
In defect number 2, the address of the petitioner is mentioned as new director has been appointed in this case because earlier one had expired in 2017. So a new address has been provided. So this may be ignored.
This Manoj Singh has expired.
Yes.
When?
In 2017.
2017. Wakalatnama is of Manoj Singh executed on 11/3/23.
Neeraj Singh has expired. Neeraj Singh was the earlier petitioner, earlier director. He has expired, and in his place, Manoj Singh is now the new director.
Okay.
Whose address has been given.
So what is the objection?
Leadership. The defect has been pointed.
What is the defect? What is the remaining defect?
This was pointed as that this may be confirmed as connected to the earlier case of Demo and Wakalatnama of earlier case. In earlier case, Pankaj Singh was the director and his address was given, and in this one, Manoj Singh is the new director and his address is given. So this may be ignored.
Address detail of the sole petitioner may be given as per the connected case in the memo in Wakalatnama. Okay. The learned counsel for the petitioner.
And there is one more defect. Defect number 4. That is a statement of watching is missing in the affidavit. Your leadership, we have annexed authorization letter in annexure number 2 of Manoj Singh. So this may be ignored as well.
This case was dismissed for default. You were traceless.
Your leadership, earlier Wakalatnama was.
Anyways, counsel for the parties are present. She submits that 2 defects be ignored. With regard to defect number 2, she submits that the earlier director has expired and therefore the case has been filed through the new director. she also refers to defect number 4 to submit that the letter of authorization has been filed along with the petition. And therefore the said defect be ignored. Considering the aforesaid submission, the defect in connection with defect number 2 and 4 are hereby ignored for the present, subject to any objection which may be raised by the respondent. So far as if there are any other defects, the same be removed by 12th of January preemptory. If the defects are if there are no defects, post this case on 19th of January.
For orders item 11, CMP 717 of 2019.
Why is it listed for orders?
Notice has been served properly.
ये मौसमात कलावती देवी का केस से हम बहुत परेशान हो गए. How many times this case is coming? You get the case dismissed for default. It's a burden on you and as well as to the court. CMP, notice has been served. Who is for the private respondent?
Already properly served.
Everybody has been served.
Yes. This was the latest.
Any reply you are for the private respondent? Do you want to file any reply in connection with any of the interlocutory application or any petition?
I will seek permissions.
Permission. Who is Rakesh Kumar Sinha? You are appearing for which respondent?
3, 4, 10 to 12, 18 to 20, 24,
3, 4, 10 to 12,
18 to 20,
18 to 20, 24, 26 to 30,
31 to 33 and 37.
What about 5 to 9? Where are they? You have to verify it, no? Who has appeared, not appeared.
For some.
I don't know. You have to tell us. If any counsel is appearing for some of the respondents, you have to tell us. Record देखिए. Counsel for the petitioner prays that the matter be posted on next Friday so that he can go through the records and verify as to who are the counsels for the private respondents and as to whether the service of notice is complete. In the meantime,
Service of notice is
you please check who is appearing, not appearing.
that is
You just check. Counsel for the in the meantime, the counsel for the respondents may file reply to the various interlocutory applications as well as the main petition, as well as to the main petition. Post on next Friday. आप चेक कर लीजिए ना. You have such an able junior, उनको बिठाइए, है ना? उनको बिठाइए. कौन
वही दिक्कत सब हो रहा है.
हो जाएगा, अगला डेट में रेस्टोर हो जाएगा. Yes.
Item 12, CMP 470 of 2020.
What is it?
Certificate notice for certificate service, application for certificate service was to be filed.
Filed?
But not could not be filed because the lady is not coming Lord for a longer time, and the person who was in leave Lord is also not operated.
If the lady is not coming, then under such circumstances we will not pass any order. We will just dismiss it on account of no instructions. If she comes again, you file restoration.
Lord, I will file Lord,
प्रेमट्री कर देते हैं.
The person who was in leak, my lord, he has got operated in the hospital, my lord. Therefore, my lord, 4 weeks.
लास्ट इंडल्जेंस आपको 6/10/23 6/10/23 से ही इज इन द हॉस्पिटल.
4 weeks का टाइम दे दिया जाए. जो लीक में था उसका ऑपरेशन.
कुछ भी बोलते. 6/10/23 was the order passed. You have not taken any steps. It was by way of last
एक
indulgence.
और दे दिया जाए, एक और दे दिया जाए. हम लोग मुश्किल हो जाता है. आदिवासी लेडी,
आदिवासी लेडी को और पुअर मत बनाइए अपने पुअर असिस्टेंट से.
बहुत
वो आदिवासी, आप तो आदिवासी नहीं है ना. देन ऐसा बात नहीं बोला करिए. प्लीज कीप ट्रैक. लिखिए CMP number 470 of 2020. Counsel for the parties are present. Counsel for the petitioner seeks adjournment to comply the earlier orders of this court. He submits that the earlier orders, that in spite of last indulgence having been granted on 6/10/2023, the order could not be complied as the concerned person is hospitalized. Post on 19 January.
19th.
इसके बाद 2 केस के बाद 15. Item for press filing, item 30. ABS 6439 of 2023.
It has become infractuous. Arrested. ABA number 6439 of 23. Counsel for the petitioner, Mr. Sushant Kumar Sinha.
On behalf of the Mr. Sushant Sinha.
Counsel for the petitioner, Mr. Altamash Khan. On instructions of advocate on record, Mr. Sushant Kumar Sinha seeks permission to withdraw this anticipatory bail application by stating that the petitioner has already been arrested. Permission is accorded. This petition is dismissed as withdrawn.
Item 14. BA 8746 of 2023.
What is the stage of the case? Stage only.
Cognizance has been taken, page number 37.
Page number
37. Final form was submitted against this petitioner, showing lack of evidence. Subsequently, cognizance has been taken by the magistrate. Final form is on page number 33.
your anticipatory bail application was rejected as back as in the year 2019,
Because,
and thereafter you did not surrender. Cognizance was taken.
final form was.
Just a moment. Final form was, that does not end the criminal case. Submission of final form is not the end of the criminal case. Cognizance was taken, warrant was issued, 82, 83 was also issued, right? What is the allegation against you? And you had moved earlier. No.
This is first time this case is coming, my lord, and similarly situated co-accused case by this honorable court, lordship, is pending in this honorable court by this bench, my lord, and next date is fixed on 8/12/2023.
Bail application.
Bail application.
His bail application is pending.
Bail application.
BA number?
BA number 8427/23. In which the state was directed to file counter evidence, the state of the trial has been filed.
Your name is Shivlal Mehto.
Not named in FIR, name transferred on the basis of confessional statement of Rajiv Gop, who has been acquitted by the alleged court below. Annexure 4 is the acquitted order also.
You can't have any advantage of that. What is the date of FIR?
Date of FIR 14/2/2019.
What is the allegation?
So when accept confessional statement, there is no allegation.
The allegation is confessional statement.
No, Your Worship.
Read the allegation. Read the FIR.
सभी में निवेदन कहना है कि मैं किलो देवी पति सचिन सच आगे में दुख की बात करना चाहती हूँ कि मेरे पति विष्णु अहिर उम्र 40 वर्ष दिनांक 3/2/19 बुधवार को जमीन का ऑनलाइन कराने का बात कहते घर से जुमला के निकले थे और कल शाम को वापस आते समय किसी अज्ञात व्यक्ति द्वारा मेरे पति को पत्थर से पूछ कर हत्या कर दिया गया। रात में जब घर वापस नहीं आया तो अपने स्तर से काफी खोजबीन किया, फिर भी नहीं मिले। सुबह 8 बजे लगभग पता चला कि किसी व्यक्ति का शव जमा खड़िया ग्राम सदस्य के खेत पर है। उस सूचना पर घटनास्थल पर गई तो मेरे पति का शव था। मेरा दावा है कि किसी अज्ञात व्यक्ति के द्वारा पत्थर से पूछकर मेरे पति की हत्या कर दिया गया है। अनुरोध है कि उचित जांच पड़ताल कर अज्ञात अपराधी के खिलाफ कानूनी कार्रवाई किया जाए।
And stage is only charge sheet has been cognizance has been taken. Charge not framed. What is the stage of the case?
I will verify.
Counsel for the parties are present. Office is directed to call for a report from the learned court below regarding the present stage of the case. Post this case on.
Case is pending 8/12/23.
8/12/23. Okay.
In the same region.
Okay. Call for a report regarding the present stage of the case. At this, counsel for the opposite party has submitted that the case of co-accused is pending before this court in BA number 8427 of 23, which is fixed on
8/12/23.
8/12/23 before this bench. Post this case on 8/12/23 along with BA number 8427 of 23. उस दिन आ जाएगा सारा कुछ। आपका काउंटर फाइल हो गया उसमें? तो दोनों का इसमें भी फाइल कर दीजिए। In the meantime, the opposite party shall file a counter affidavit in the present case. उसमें आएंगे, इसमें भी कर दीजिए।
For admission, attempt 15, WPC 1348 of 2017. Online video Mr. G. Respondent.
The land has been submitted in favor of the petitioner for construction of multiplex malls.
Who is there for the state, for the respondent? Mr. Mishra, are you appearing?
Yes, ma'am. I am for respondent number 6, Tata Steel.
So what have you done? What have they done?
Actually, JNSC was supposed to file the counter affidavit.
Where is JNSC? This case has been assigned to me. Assignment है?
It is written as assignment.
JNSC has already filed the counter affidavit.
They have filed it?
11/5/2017.
Where is? I don't find it here.
I have received.
They are not here and they have not filed it. देखिए तो फाइल हुआ?
11th May का affidavit हुआ।
They are not filed it. Check करिए। They might not have paid the cost. State has filed counter.
There is the counter of respondent number 6, madam, the assistant engineer.
Assistant engineer of
Jamshedpur.
Council for the State and Jamshedpur Notified Area Committee were allowed 4 weeks time to seek instructions and file counter affidavit. In case they are unable to file the counter affidavit they may do so within the extended period of 2 weeks. Failing which, They will pay a cost of rupees 3,000 to the petitioner.
But that is of the year 2017 or taken such another cost has been submitted.
A copy of the order has also been handed over to you.
That is
So?
there in the requirement.
So your right to file the counter affidavit is closed. No means what?
But so far as the cost part is concerned,
No cost, where is your counter affidavit?
that is not counted.
WPC number 1348 of 2017. Counsel for the petitioner seeks adjournment. इसमें नोटिंग दिखा रहा है कुछ काउंटर फाइल हुआ है, चेक कर लीजिए कहाँ है। हाँ, ये देखिए नोटिंग में है। See a special officer are kept on record. है तो इसमें काउंटर का फॉर्म। When do you want? You choose your date, madam. But on the next date, don't seek adjournment. 17th, we are in DB, no? 19th January.
कोई फाइल नहीं है।
नहीं फाइल हूँ, कैसे लिखा है यहाँ?
2017 का है।
2017 का ही ऑर्डर है। 2017 का फाइलिंग होना चाहिए ना साथ में। इसका कम करो।
Format 6.
Your construction is going on.
No, you're not. 90% of the construction was already completed and thereafter no construction.
So you're not interested in constructing it anymore.
Lordship, we have to construct.
So
That is the-
you are seeking time. It means that you are not interested.
Yes.
Yes means what? Not interested.
We are interested in Lordship.
Post this case on 2nd of February. In the meantime, the parties to complete the pleadings in terms of and if so required, the cost will be also deposited. If so required, the cost in terms of 3/7/2017 be also deposited.
Madam, by presence for respondent number 6.
Respondent number 6, Mr. D.M. Mishra appears. You want to file his reply?
Yeah, depending upon the basis.
Construction is going on, Mr. Mishra.
I will have to seek instruction.
A multiplex to be constructed and the person who is constructing the multiplex is not interested, apparently. So please find it out.
Later I will find that out.
Item 16, CMP 244 of 2020.
Yes, petitioner.
Restoration application.
Let record.
This is for the board work for the plant to the country order. Dated 15th of July. At least 14 of the day. And there has been delay also was filing the restoration.
So what do you want?
Compliance of the blood priority order.
So what do you want?
Several writ applications were there, but BI.WPC number 5882 of 2020.
The order reflects that in spite of repeated opportunities, the defects were not made, which is correct.
Yes, yes. But unfortunately, there was communication gap between the lords, council and the clients lords, and at least the restoration application has been filed also. We are still not aware. So what are the defects in the mandate application? We have to look at that. It has to be removed, my lord. So far as, my lord, the writ of application is concerned, Lord, I had the occasion to appear in batch of cases which my lord had.
Even the court fees has not been filed.
Court fees has not been filed.
That is not my duty to tell you what are
I'm
law.
sorry.
Even the court fees of in the writ petition was not filed. So I think that is also that is not
has
the
to be
fault
filed.
of the.
That has to be filed. That
How
has
much
to be
time?
filed.
So far as this is concerned, state is the respondent.
State is.
CMP number 244 of 2020. Counsel for the parties are present. This petition has been filed for restoration of WPC number 5882 of 2015, which stood dismissed on account of non-compliance of preemptory order dated 13/7/2018. In as much as the defects as pointed out by the office in WPC number 5882 of 2015 was not removed within the stipulated time. How much time will you take to remove the defects in the writ petition?
Yes, the criteria CMP में new councils are there, Lord. Again, since
How much time will you take to remove the defects in the writ
19th
petition?
by 19th of January.
Okay. The learned counsel for the petitioner has submitted that the surviving defects in the writ petition will be removed by 19th of January 2023. Considering the
There has been,
aforesaid
Lord, some Lord, delay also. Limitation application.
CMP में कोई दिक्कत नहीं है writ petition का
हाँ ये है 3287.
IA number 3287 of 2020 has been filed seeking condonation of delay of 660 days in filing the petition for restoration of the writ record. The learned counsel submits that due to communication gap between the petitioner and the counsels, there has been delay in filing the petition for restoration also. Considering the aforesaid submissions, IA number 3287 of 2022, seeking condonation of delay is allowed. So far as CMP number 244 of 2020 is concerned, the time for removal of defects in WPC number 5882 of 2015 is extended till 25th of January 24. The CMP is accordingly disposed of in their aforesaid terms. It continues to be preemptive.
Exactly. Lord,
फिर नहीं रिमूव करिएगा फिर से डिफेक्ट
kind permission. I advocate on records and we have to Lord see the file of the writ application.
कोई परमिशन की जरूरत नहीं है, सिर्फ कोर्ट मास्टर से मांगने की जरूरत है. कोई परमिशन की जरूरत नहीं. You can see any file you want. There is no problem about it. Call करिए next case.
Item 17 WPC 3887 of 2020 along with item 80.
Why an adjournment? You have not given any advance notice of adjournment. This is a voluminous record. Yes,
एक मिनट लास्ट ऑर्डर से देखिए.
I've seen it.
They have not complied with my lord's order in few spirits also.
What is to be done?
They were supposed to file a supplementary counter-review stating the details of the amount amounting to 7 crores and odd.
Okay.
And they filed a vague statement for even.
They have filed an affidavit.
Proceed.
Where is that?
On 8th November 2023.
possible कर दिया जाए लॉजिक मींस दिस क्लियर आल्सो
बताइए जरा क्या चीज है?
पैरा 14 नोट
पैरा 14
पैरा 14 15 जो इट काइंडली स्लो
पढ़िए.
that it is stated that letter number such and such Jamshedpur dated 26/4/23 has been served to the petitioner along with revised provisional final bill amounting to rupees 7 crores 49 lakhs and odd for only and rupees 2,500 as meter removal disconnection charges at the final reading and Nigams meter and material removal report dated etc. Next, that on perusal of the said revised provisional bill, the balance calculation projection of bill amount has been given to arriving the total bill amounting to such and such.
What was the direction?
You the details of this amount, Lord. It is 7 crores 49 lakhs.
Who has filed this affidavit?
Executive engineer. CNR.
कब चाहिए आपको? एग्जीक्यूटिव इंजीनियर को आना पड़ेगा अपना एफिडेविट एक्सप्लेन करने के लिए. अदरवाइज आई विल टेक एवरी स्टेटमेंट मेड इन द रिपिटिशन एज करेक्ट.
इसको दो केस के लिए पॉसिबल कर दिया जाए. अपने सीनियर को बुला लेते हैं.
कौन है आपके सीनियर?
मिस्टर सुकुमार यादव.
बुला दीजिए उनको. उनको बिजली अच्छे से समझ में आता है. बुलाइए.
Pattern 19, WPS 1850/2021, along with pattern 20.
क्या है ये?
It's a promotion matter, the counter affidavit, as per lawsuit's direction, the counter affidavit has been filed on 24th of 11/2023. So I need to reply the counter affidavit.
दोनों एक साथ है, विथ है?
हाँ, with है. और एक
क्या लिया इन्होंने? काउंटर एफिडेविट में ऐसा कौन सा बात बोल दिया है कि आपको रिप्लाई की जरूरत पड़ेगी?
नहीं, जरूरत पड़ेगा. उसमें I have to deliver on record the statute. Promotion matter from reader to professor under the statute of 10-year time of promotion. Now, the 10-year.
Who has filed the affidavit?
Affidavit has been filed by the state and university.
Counsel
And
for
in
the
the second
parties are
case,
present.
only state has filed, university has not filed.
The same affidavit.
University has filed.
Who is for the university?
In first case,
AK Mehta, who is not.
आप किन की तरफ से हैं? मिस्टर AK मेहता की तरफ से आप हैं? यूनिवर्सिटी की तरफ से आप हैं? Where is the counsel for the university?
AK Mehta. In the second case.
सेकेंड केस में नहीं फाइल हुआ है.
First case में हमने फाइल किया. Second case में.
फर्स्ट केस में दोनों ने फाइल कर दिया है. ऑल द रेस्पोंडेंट्स आर फाइल काउंटर एफिडेविट. फर्स्ट केस में दोनों केस विद करके लिखिए. इन फर्स्ट केस लिखिएगा. Counsel for the petitioner has submitted that university has that all the respondents have filed their counter affidavit. He prays for 1 week time to file a rejoinder to the same. Let the rejoinder be filed by next Friday. Post this case on next to next Friday जो भी डेट पड़े. ठीक है?
2 weeks time दे दो.
2 weeks टाइम दे दीजिए. तो नेक्स्ट टू नेक्स्ट फ्राइडे तक का टाइम दे दीजिए. उसके बाद जनवरी में ओपनिंग फ्राइडे को डेट दे दीजिए.
Second case में भी दे दो.
So far as the other petition is concerned, state has filed the counter affidavit.
State has filed, university has not.
The university has not. The respondent university has not filed. Nobody is appearing on behalf of the respondent university. And it is reported that Mr. A.K. Mehta appears for Ranchi University. In this case.
Not Vinoda Bihari. BBK.
From the Mr. A.K. Mehta, advocate appears for the respondent university. Let this matter be posted on same date. And in the meantime, the petitioner may file rejoinder to the counter affidavit filed by the state, and the respondent university shall file the counter affidavit within 10 days from today, failing which the right to file counter affidavit will no further time will be granted to file contract unit in the case. Let a copy of this order be handed over. A soft copy of this order be forwarded to Mr. A.K. Mehta, Advocate, for compliance.
5th January.
Opening Friday.
Item 21, WPS 3279 of 2021.
Pray for some time, my lord. Just my lord.
Time for
Before,
what?
my lord, I have taken the brief ballot and 5 o'clock now, my lord. Disturbing me. I have not gone through the pleading, my lord. And I lost direction, my lord. I have to file synopsis, list of dates, etc.
Sir, we have already filed supplementary affidavit on behalf of RNC and on behalf of.
आपके पास इनका काउंटर एफिडेविट की कॉपी आ गई है?
ये सब चीज आ गया हम लोग
रिप्लाई फाइल करना है?
फाइल करना हम देख नहीं पाए कल ही हमने मुकदमा फाइल किया है उसके बाद हम देखे नहीं ये है कि प्लीडिंग कंप्लीट है खाली हमको सिनॉप्सिस
लिख रहे हैं प्लीडिंग कंप्लीट है, काउंटर का जवाब नहीं देना है आपको?
काउंटर का देखे नहीं इसलिए
तो फिर कैसे लिख दे कि प्लीडिंग कंप्लीट है? नाम बताइए।
विजय शंकर अभी वो उसमें आया नहीं है लिस्ट में कल फाइल किया
फाइल कर दिए हैं।
हाँ फाइल कर दिया
Counsel for the parties are present. Mr. Vijay Shankar Jha for the petitioner. He submits that he has entered appearance by filing a fresh wakalatnama in the present case. The respondents submit that the required counter affidavit has been filed by them. Supplementary counter affidavit has been filed by them. The petitioner seeks adjournment to file a response to the supplementary counter affidavits. Post this case on 5th of January 24. The response to the supplementary counter affidavit should be filed latest by 16th of December. If no such reply is filed, the case will be taken up on the basis of materials on record.
Item 22, CMP 069 of 2022.
Yes?
Your Lordship, we appear on behalf of same. I seek time to reconstruct the file as the file papers are missing, Your Lordship, from our records.
Which file paper, CMP or the writ record?
The CMP itself, Your Lordship, we just have a copy of the supplementary affidavit. The rest, the petition itself is missing from our records.
It is an application for restoration of contempt case.
Yes,
What
we
objection
can.
do you have?
None of the documents are available with us. We have sent a communication.
So let the contempt be restored.
Your Lordship, we have no knowledge of the document, but since it's a company matter,
What document? It is just an application for restoration.
I agree.
The case was dismissed on account of non-compliance of preemptory order. So
Yes,
what is it? What's the big deal about it? He will give you a copy. अब देंगे उनको copy?
Yes, it's just given me a copy.
CMP number 669 of 2022. Counsel for the parties are present. This petition has been filed for restoration of contempt case within bracket civil number 723 of 2021, which stood dismissed on 12/8/2022 on account of non-compliance of order dated 29/7/2022. Defect removal था? The learned counsel submits that on account of inadvertence, the defects could not be removed. That's what the defects could not be removed. After hearing the counsel for the parties and being satisfied with the cause shown by the petitioner for non-removal of defects, the contempt case civil number 723. दिखाई जरा contempt case वाला order. हो गया डिस्मिस हो गया.
On 12 August 2022 as per para 5 regulation.
12th August 22.
Yes, sir.
कहाँ है 12th August 22 का कोई ऑर्डर है इसमें?
I have a 5-year leadership of the question that I was given right now.
अच्छा, okay.
It was dismissed for default.
Okay, the time to remove the defects in contempt case within bracket civil number 723 of 2022 is extended till 19th of January 2023. If the defects are removed within the stipulated time, the contempt case civil number 723 of 2021 be listed before this court on 2nd of January 2024. Preemptory है इसको. It continues to be preemptory. CMP dismissed.
नेक्स्ट वीक नहीं कर देंगे बट 2 वीक्स का टाइम आ
हम आपको ज़्यादा टाइम दे दिए हैं, फिर भी आप कर दीजिए तो गनीमत. आपका प्रीएम्प्टरी टाइम एक्सटेंड कर दिए हैं, ऐसा नहीं हो कि दोबारा डीएफडी हो जाए.
ऑफिस सबको ना है कि आपका डीएफडी हो गया तो पार हो चुका
कोई बात नहीं, कोई दिक्कत नहीं है. आप अभी तो देख लीजिए क्या क्या डिफेक्ट है.
देख लिए मैंने.
देख लिए, बहुत अच्छी बात.
Item 23 CRMP 3491 of 2023. कितनी सवाल है?
यही मैटर है. आप थे एक्सटेंड कर देते हैं टाइम. CRMP number 3491 of 2023. Counsel for the parties are present. Counsel for the petitioner submits that this petition has been filed for extension of time to deposit the fine amount as directed by the order dated 8/3/2021 in criminal revision number 1172 of 2013. The learned counsel submits that on account of intervening COVID situation, the fine amount could not be deposited, and on account of non-compliance of the order, petitioner number 1, petitioner number 2 has surrendered. Custody.
Taken into custody.
Has been taken into custody. The learned counsel submits that if the time is time period for deposit of the fine amount be extended by till बताइए
2 weeks more. Till 15th.
18th August कर दे. 18th December till 18th of December. Learned counsel for the opposite party has no serious objection to the prayer for modification after hearing the counsel for the parties and considering the aforesaid submissions made by the counsel for the petitioner and after going through the present petition, the order dated 8/3/2021 passed in criminal revision number 1172 of 2013 is modified to the extent that the fine amount as stipulated in para 13 of the said order be deposited by 18th of December 23. That's it.
If the fine amount is deposited, the petitioner number 2 may be released. Since he is in custody.
Since the time period for deposit of the amount has been extended, upon deposit of the fine amount within the stipulated time, within the extended time, upon deposit of that fine amount on or before the extended period, the petitioner number 2 be released if he is not wanted in any other case. Right? Let this order be communicated through fax.
So,
कहाँ जाएगा ये फैक्स में? किसको?
लातेहार।
हाँ,
लातेहार।
लातेहार। तो इसका जो रिवीजन में जो हम लोग पैराग्राफ देते हैं ना, वो दे दीजिएगा, सही जगह कम्युनिकेट हो जाएगा।
Pastoral case item 17, WPC 3887 of 2020, along with item 18.
और ये जो एफिडेविट फाइल किए हैं, हैव यू सीन द लास्ट ऑर्डर एंड देन फाइल्ड इट?
Actually, this case was being handled by Manoj Kumar. Today he is out of station, my lord. He has just handed me forward the file, my lord. I will. I have talked with my friend, my lord, senior friend, my lord. He has stated about the previous order, my lord. I will take it, file fresh affidavit. That will be more appropriate, my lord, if your lordship permits, my lord. Because that affidavit does not speak much about the amount.
The breakup, the
breakup of
breakup
the
is
7 crore
required, no?
something, my lord.
Yes, it's a. Although it's just a short order, but it speaks a lot about your bills.
My lord, I have not gone through the file, but I will.
7 करोड़ का बिल बना दिए हैं, कोई ब्रेकअप नहीं है, पॉकेट से कहाँ से आदमी देगा? 7 रुपए आपसे मांगेंगे तो हिसाब किताब मांगेंगे आप 7 करोड़ रुपए मांग रहे हैं विदाउट हिसाब किताब, और सुन के ऑर्डर किए थे, इसीलिए दैट इज क्लिंचिंग, राइट? सो व्हेन शुड आई पोस्ट इट? चलिए 2 वीक तो हम दे देंगे, लेकिन अगर 2 वीक में नहीं होगा ना तो फिर फर्दर टाइम नहीं देंगे। फिर इनका पिटीशन में जो जो कहानी लिखा है उसको हम सही मान के केस को डिसाइड करेंगे।
ठीक है,
ठीक है। दे वर आस्किंग फॉर एन इंटरिम रिलीफ ऑन द लास्ट डेट फॉर रेस्टोरेशन ऑफ इलेक्ट्रिसिटी, जो हम बोले कि डिसाइड ही कर देंगे तो फिर क्या ज़रूरत है। अब आप जो है ना तो इंडस्ट्री को रन करने देंगे, ना ही पैसा का हिसाब किताब देंगे। लिखिए WPC number 3887 of 2020, counsel for the
my appearance can be recorded.
हाँ, counsel for the parties अपना appearance record कर लीजिए। इनका Mr. A.K. Yadav, standing counsel JUVNL, Mr. S.L. Agarwal for the petitioner in both the cases. The counsel for the petitioner has submitted that though an affidavit has been filed pursuant to order dated 13/10/2023, but the same is not in terms of the said order. Upon this, the counsel for the respondents has submitted that within a period of 2 weeks, he shall file the required affidavit in terms of order dated 13/10/2023. Let the required supplementary affidavit be filed on behalf of the respondents. In case the affidavit is not filed in terms of order dated 13/10/2023, no further time will be granted and the case will be decided on the basis of pleadings and materials available on record. कब रख दें?
2 weeks के बाद करेंगे।
ओके, बताइए कब रख दें?
18
दिसंबर
स्टार्ट हो गया है।
ठीक है, पोस्ट ऑन 18 कैसे होगा? 13 दिसंबर
13 में 2 वीक पूरा नहीं हो पाएगा।
2 वीक पूरा नहीं होगा।
20
दिसंबर 20 दिसंबर को रख रहे हैं, लेकिन उस दिन हो नहीं पाएगा।
22nd दिसंबर 24 का कैलेंडर।
ओह ओके, ये है क्या? अरे तो सारा डेट हम उसी हिसाब से दे दिए। 20 दिसंबर भी नहीं हो पाएगा ना, डीबी चल रहा है मेरा।
22nd हो सकता है।
22nd को हम रख रहे हैं जिससे कि आप ऑर्डर का कंप्लायंस करें। लेकिन चांसेस बहुत कम है कि उस दिन केस होगा, लास्ट वर्किंग डे है। इनको इसलिए बता रहे हैं क्योंकि इनके सीनियर कोई आते हैं इसमें। देखिए, हमको कोई कन्वीनियंस का बात नहीं है, बात ये लास्ट वर्किंग डे है। व्हाट इज द लाइक्लीहुड ऑफ द केस बीइंग टेकन अप? तो 6 जनवरी को रख देते हैं, ठीक है? 6
5th
अच्छा 5th January, 5th के बाद वाला week.
then 12th January.
12th January under the heading for final disposal. Parties to file their respective written submissions, list of dates and the judgments which they are seeking to rely upon. That's all.